Standard utility service agreements carry a mandatory obligation known as the implied covenant of good faith and fair dealing. This rule requires companies to implement their contracts in a way that doesn't undercut the purpose of the transaction, and it can be used to compel the removal of collection accounts from your credit report. Many consumers rely on standard dispute letters, claiming a debt isn't mine, but these letters rarely succeed in the modern credit landscape. Because credit bureaus use automated systems to match your name and balance against the provider's database, the debt is verified and the collection remains. The U.S. Court of Appeals for the Fourth Circuit recently clarified the rules for these disputes in Roberts v. Carter-Young. The court ruled that data furnishers must investigate disputes involving information that is objectively and readily verifiable. This shifts the legal strategy from debating the amount of the debt to challenging the company's right to report it while you are on a payment plan. To execute this, you need to draft a 623 dispute letter. This document bypasses the bureaus and forces the utility company to investigate their own internal records for a breach of contract. First, identify a utility collection for water, gas, or electricity on your current credit report. For this strategy to work, you must have an active or recently completed payment arrangement with that utility company. Legally, a payment arrangement functions as a modification of your original agreement. As long as you adhere to the plan, the legal doctrine of frustration of purpose suggests the account is effectively in good standing, as the purpose of the plan is to resolve the delinquency. The contradiction occurs when a company accepts your payments under this new arrangement while simultaneously reporting you as being in collections. This reporting behavior denies you the primary benefit of the payment plan, the return to good credit standing. This behavior constitutes a breach of the implied contract of good faith. The company is using the credit reporting system to devalue the very arrangement you are currently paying them to fulfill. To document this breach, retrieve your most recent utility bill or an official email that confirms your active payment plan status. Look for the section on your bill that confirms you are current on a deferred payment plan. This is your primary piece of evidence. This document invokes the account stated doctrine. When a utility sends a monthly bill showing you are current and you pay that amount, both parties have admitted to the accuracy of that status. It becomes an objective fact in the company's own records. A utility company cannot easily justify reporting a derogatory status to a credit bureau that is contradicted by their own account-stated billing history. Address your dispute letter directly to the dispute department of the utility company or collection agency. In the language of the Fair Credit Reporting Act, they are the data furnisher. Do not send this to the credit bureaus like Equifax or Experian. Those agencies are not data furnishers. They simply compile what the utility company provides. By sending your dispute directly to the source of the data, you trigger different legal obligations than a bureau-level dispute. This direct routing bypasses the bureau's automated screening and forces a person at the utility company to review your file. Under Section 623 of the FCRA, furnishers are prohibited from reporting information they have reasonable cause to believe is inaccurate. Your billing statement provides that reasonable cause. In your letter, include this specific sentence. The reporting of this account as a collection constitutes a breach of the implied covenant of good faith and fair dealing because I am in active adherence to the payment arrangement established on, followed by your date. By combining this legal phrasing with your bill, you require the furnisher to conduct an investigation into the status of the debt based on their own available evidence. This document forces the furnisher to investigate their own contractual violation. If they ignore it, they move from a simple clerical error to a willful reporting of inaccurate data. Print the 623 letter and attach the copy of your bill showing the payment plan. Mail this package using certified mail with a return receipt. This is the only way to establish a legally significant paper trail. The green card provides physical proof of the exact date the company received your evidence. That delivery date starts a 30-day clock. The furnisher must investigate and respond within this time frame, or they risk violating federal law. Once the certified package is delivered, the burden of proof shifts to the data furnisher. They must now reconcile their internal records showing you are current with their credit reporting that says you are in collection. If the furnisher fails to correct the record within 30 days, their continued reporting can be classified as a willful violation of the FCRA. This creates significant legal exposure for the company. Under the FCRA, consumers can sue for statutory damages of up to $1,000 per violation, plus their own attorney's fees. Because it is difficult for a company to defend a lawsuit where their own billing records contradict their credit reporting, many furnishers choose to delete the collection item entirely rather than risk litigation. Stop sending generic disputes and start enforcing the terms of your contracts. Subscribe for more breakdowns on how to use consumer law to protect your credit profile.